Before you mail your marriage-based green card application to USCIS, please stop and check for these mistakes. These are the type of mistakes that can lead to delays on your case, request for evidence, notice of intent to deny, and even a denial. Many people think that a marriage-based green card case is all about the forms, filling out the right forms with the right information. Many people think that filling out the forms is the hard part, but the real issue is whether the forms, the evidence, all the filing fees, all of that work together to support your case. Today, I'm going to go through the top 10 mistakes that I see in marriage-based green card applications, and hopefully you are not making any of these mistakes. The first mistake is using outdated forms. USCIS is always updating their forms, so you want to make sure before you file your I-130, I-130A, I-485 that you are filing the latest version of those forms. Speaking of the I-485, USCIS has indicated that they will be updating the form I-485 very soon. So make sure that you are checking the actual date for each of these forms before you file to make sure you are filing the latest version. Do not assume that the forms that you downloaded a couple months ago are still the latest versions, okay? I do this in my office before any form goes out. I am going to the USCIS website to make sure that it is the latest form that is going into that application. The second mistake that I see people making is with the signatures. The forms are missing signatures, or the signatures are in the wrong spot. Remember, every single form needs a signature and a date. An I-130A may not need a signature if the person you're filing the I-130 for, if your spouse lives outside of the US, the I-130A does not need their signature. But if your spouse lives in the US with you and you're filing that marriage-based green card application, it needs their signature. So make sure you are filing your applications with the signatures in the right spots. And here's a major tip. USCIS does not accept electronic signatures. So when you are mailing in your application, make sure that you are actually signing the forms, printing the forms and signing them, and not doing electronic signature. Mistake number 3 that will definitely get your application rejected is having the wrong filing fee. If you are filing your application, you need to check what the current filing fee is for the forms that you are filing. So for a marriage-based green card application, for example, if you're filing an I-130 and I-485, those two forms need their own separate filing fees. They have their own separate filing fees. So you need to make sure that you're including the right amount for that filing fee. Now, if you're including a work permit, an I-765, or a travel permit, an I-131, you want to also include the fees for those forms. So if you're filing the case and you are not including the right fees for the forms that you're filing, USCIS will reject your forms if the forms require a fee. I am not going to be telling you what those fees are in this video because the fees can change. Someone may watch this like 6 months from now. Hopefully the fees do not change because we really don't want them to go up. But if the fees do change, you want to make sure that you are checking the fees on the USCIS website before you file, okay? I'm not going to tell you what the fees are because I want you to go check the fees before you file. Of course, for our clients, we are doing this for them, letting them know exactly what the fees are at the time that we're filing the forms, okay? Because again, the fees do change, the forms do change. Mistake number 4 that I see is inconsistent address history. USCIS is not looking at your forms in isolation. So when they're looking at an I-130 and I-130A and that I-485, they're looking at them as a group of forms that make up your case. So So if there's inconsistencies on your address history between your I-130A and your I-485, or your I-130 and your I-485, that's going to cause some questions, and you do not want to start off your process with questions, okay? You want to make sure that your forms are consistent throughout, especially when it comes to the address history with where you lived and the dates that you lived there. You want all of those things to be consistent throughout your entire application, and also your evidence, okay? Remember, forms are not being reviewed in isolation. They are being reviewed with the evidence that you are submitting. So the evidence has to match what you are telling USCIS on your forms. Mistake number 5 is weak marriage evidence. So you are filing a marriage-based green card application. One of the biggest requirements for the marriage-based green card application is you being able to prove to USCIS that you entered into your marriage in good faith and you're planning on building a life with your spouse. Sending in just pictures from your wedding is not going to be enough to prove that. In addition to including pictures from your wedding, you want to also look into including these other types of evidence: a shared residence, shared finances, shared insurance, children, travel, your photos over a long period of time, your communication, and if at all necessary, affidavits from family and friends that knows your relationship. Wedding pictures are helpful, but they should not be the only evidence that you are sending to USCIS to prove that your marriage is real. Mistake number 6 is not explaining unusual facts or red flags in your case. So basically, if there is something in your case that would make a USCIS officer pause, you want to be the one to bring it up. Do not brush it off. Do not act like it doesn't exist, because guess what? USCIS officers are trained to find those red flags. So you want to be the one to address it in the best light possible. Examples of these things could be you are living apart from your partners. Maybe your partner is in school in another state, but your home is where you live, but they're currently away for school. That is something you can explain in your application before you get to your interview, right? Before the officer is having you in your interview questioning you, you can explain that with documentation of where your spouse is going to school, what year they are in school, why they're going to that specific school, if it's a school that has a specific program that they need to be in. And then finally, how are you two maintaining your relationship even with living apart? So that can include travels to see each other, right? That can include telephone calls, text messages, however you are staying in contact with your spouse while you're living apart. You want to address that, because again, that's going to raise questions for the officer. Mistake number 7 is all about the affidavit of support, the form I-864. This is where a lot of people mess up. Your application, when it comes to your marriage-based green card application, cannot be processed, basically cannot go beyond a certain point if your affidavit of support is not accurate or you do not meet the requirements for sponsorship. So first thing that I noticed with the affidavit of support is that the income is too low, but without knowing how much income you need for your household size, you may fall into this trap. So you want to make sure that you are checking your income against what the poverty level is according to USCIS. They have a chart on their website. It's the I-864P, and it gives you exactly what income level you need to be at for your household size. Another mistake I see with the I-864, that affidavit of support, is people putting in the wrong household size. You need to make sure that you're calculating your household correctly, because incorrectly calculating your household can lead to you thinking you need more income than you actually do, or thinking that you need less income than you actually do. So that household size calculation is so important, because it can make a difference between you qualifying and you not qualifying. And then finally, making sure that you are including your most recent tax return with that affidavit of support. So you want to make sure that you're including your most recent tax return, because I have seen USCIS send a request for evidence for the tax return and people respond without including the most recent tax return, and they deny the case, the whole case, not just reject the affidavit of support. The affidavit of support is connected to the green card application. So if they reject the affidavit of support, they are denying that green card application. So you want to really make sure that you're including the right evidence for your case. The affidavit of support is one of those places that people make the mistake, and that mistake can cost you time and money if you end up getting your application denied and you have to file all over again. Mistake number 8 is missing immigration history documents. Okay, USCIS needs to know how you entered the US and what happened after you entered the US. So if you entered the US with a visa, you have an I-94. If you entered with parole, you most likely also have an I-94. They want to see that because you can only adjust your status in the US if you were admitted or paroled into the US. So if you did not have any legal admission into the US, you will not be able to adjust your status. So you need to make sure that you are providing that documentation to USCIS. If you do not have a paper I-94 and you entered with a visa within the past 20 years, go to the CBP website and look for your I-94. You should be able to pull it and print it online. Mistake number 9 is not checking your admissibility issues. Now, what does that mean? When you are applying for a green card, there are things that make you ineligible for a green card. Those are admissibility issues, things that make you not able to actually get a green card. Admissibility issues can show up in different ways. Maybe you had a criminal history that ends up being something that makes you inadmissible. You need to know that before you file your application, because again, that can delay the whole process or even lead to you being denied and being put in deportation proceedings. Past misrepresentations are something to also know, because that makes you inadmissible and you could potentially need a waiver before you can actually get that green card. So it may not be impossible for you to get the green card. You may just need a waiver to fix it. If you have had prior removal from the US, you were deported in the past, you worked without authorization in the past, and you are filing based on your lawful permanent resident spouse, not your US citizen spouse, you need to pay attention to that being an inadmissibility issue. If you have had any prior visa fraud concerns, you need to know that that will still come up with USCIS when they're looking at your green card application, and you need to be admissible for you to then be able to get the green card. So like I said, some people, after reviewing all these inadmissibility things, can see themselves as eligible and are able to file their application. Others will be in a situation where they can apply, but they will need a waiver, an extreme hardship waiver, in order to actually get the green card. And then others will find themselves in a situation where if they are consulting with an immigration lawyer based on the issues that they had in the past or that they feel would come up, that lawyer, including me, may tell them not to actually file that application because they are inadmissible and do not qualify for a waiver. So we have to look at the full picture. Are you eligible? Yes, you're married to a US citizen. Do you have anything that makes you inadmissible? And if you do have something that makes you inadmissible, can that thing be waived? And then 3, once we figure out that you do have an inadmissibility issue, we need to then figure out, can that thing be waived with an extreme hardship waiver based on extreme hardship to your US citizen or permanent resident spouse? And if we find that it cannot be waived, we may just tell you, do not file this application because this is the result of filing the application, right? So you need to consider that before you even file your application, because sometimes people file not knowing that they're inadmissible and end up getting themselves put in deportation proceedings. Mistake number 10 is filing your application without a final review. Even if you prepare your application yourself, it is still worth it to have a trained professional review your application before you file it so that they can review it for any red flags, any issues, or missed information or documentation. This is something I do for clients all the time, where they're coming to me after they already filled out their application, put their packet together, and are ready to file, but they want that final eyes on their application. I review them for everything from inconsistencies to documents matching what's on the actual forms. Because again, you are doing a full packet where USCIS is not just looking at your forms, they're looking at your documentation and looking at inconsistencies between the two. So we do that full review. Your goal is to file it correctly, clearly, and strategically to make sure that you are putting your best foot forward to get that application approved. If you have already prepared your own marriage-based green card application and you want that set of eyes on it, we at Lilly Legal offer a review-only service where I will review your forms and documentation to flag any inconsistencies that may affect your case. And if you are looking for a preparation service where we prepare your packet for you and you file it with USCIS, we do a preparation only service as well. If you would like to take advantage of either of these options, please feel free to schedule a consultation with me by going to my website, lilylegal.com, click on Contact Us, and you can pick a date and time that works best for you for us to talk about your case.